Good morning, everyone, and thank you for attending today's webinar, which is the second in our webinar series. Today, we're going to be talking about reopening issues and employer liability concerns in the era of COVID-19. On behalf of myself and my colleagues, Connor Newsell and Art Silbergeld, we're very glad to at least be able to talk to you remotely. We hope you're all doing well, and we certainly miss seeing you live, but at least none of us have to get all dressed up and ready for today's presentation. So a few housekeeping items. If you have any questions during the webcast, you can submit them through the Q&A widget at the bottom of your screen. We will try to answer these during the webcast, but if a fuller answer is needed, or if we run out of time, it will be answered later via email. A copy of today's slide deck is available in the resource widget, and we encourage you to download any of those resources or links that you may find useful. In fact, our slides probably have more content than we will be covering in detail today, and we did that for your benefit. You can find additional answers to some common technical questions located in the Help widget at the bottom of your screen. This webinar is accredited in California and Illinois for 1.5 hours of general CLE credit, and in Missouri for 1.8 hours of general CLE credit. So you get an extra 0.3 if you're in Missouri. 1.5 hours of general CLE credit in Texas is pending. This webinar is also accredited for 1.5 hours of SHRM credit and 1 hour of HRCI credit. We award CLE based on attendance for the entire 90 minutes. From time to time, you will be required to click a pop-up screen to reflect your continued engagement. So don't forget to click the pop-up screen. Certificates will be sent out to those who qualify within 48 hours of the conclusion of this webinar. If for some reason you don't receive one of those, please contact us. We value your opinions and appreciate your participation in this course. Also, we would provide the general disclaimer, which is probably also popping up on your screen, that this is not specific legal advice and this is a general discussion of the law, and you should consult your attorneys for specific questions. So, again, this is the area and topics we are covering today. Specifically, we're going to be addressing employer liability concerns, which I will address, then Connor will address workplace standards, and then Art will discuss additional reopening issues much more on a practical level as well. We are going to have some emphasis on Missouri, Illinois, and California law, but it will be a general discussion of federal law and some general common law principles. I would tell you that as a practical matter, we are not going to get into significant detail as it relates to healthcare workers and educational institutions. A lot of the nuances, we're going to be covering general principles in those areas, but God bless you all for the work you're doing, in particular dealing with those on a day-to-day basis. But there certainly will be issues and principles that apply to you, but some of the specifics may not be addressed in any detail. So the first question, when the COVID-19 and the pandemic came upon all of us, everybody was worried, of course, what's my liability? What is my liability if I have employees who contract the virus? What happens? Am I liable to them? Am I going to get sued? Also along those same lines, what if they go out while they're doing their job and they're either a delivery person or somebody who does repairs in the home, or if you are somebody in a retail function having interaction with the public, what are my liabilities to those who might contract the virus from one of my employees? Or what if my employee goes home, contracts the virus at work, goes home, and other people have big parties or birthday parties, and other people in their family contract the virus as a result, and then they go and visit other people, and where does the scope of my duty lie? People were very concerned about that. Frankly, so far, the majority of the courts which have addressed these issues have provided a little bit of sanity to that whole process, and as a result, a lot of the concerns that people have haven't turned out to be as significant as one would have expected. But generally, there are going to be some principles that we will talk about today, and you'll see how they fit in. And one of them is going to be the OSHA compliance rules. One of those is going to be CDC guidelines. You're going to hear that 1,000 times, as you probably already have, CDC guidelines. And the third, of course, is going to be whatever the local public health department, public health orders that are in place, and those guidelines and requirements. So the first thing everybody worried about was, if I'm an employee, if I have employees, how, what's my liability to them and under what circumstances? Generally, of course, which sometimes people think is a good thing, some people think it's a bad thing, is what is my liability to my employees, and am I covered by workers' compensation? The good news is, if it's covered by workers' compensation, then as to an employee, that is the exclusive remedy for the employee, and therefore they can't try to find ways to sue you outside of that, as long as it is an injury which is covered by workers' compensation laws in your state, which generally would be employees who are injured in the scope or course of their employment. That's been an open issue in many states about whether someone has been injured in the course and scope of their employment if they've contracted COVID-19. You, of course, have to prove that you contracted it at the workplace, which can be somewhat difficult because it's not like any employee is not out, or any of us aren't out in the public in other places where we could equally contract the virus, whether it's at the local grocery store, whether it's where we get a car wash, whether it's where we're walking in the park, whether we're at some crazy rally or wherever else we may be. You have to, of course, prove that you actually contracted the virus at work. And the insurance companies obviously have taken a different view on that, and no reflection adversely on insurance companies, but they're clearly saying, no, you need clear proof that you contracted the virus at work. Now, to the extent the employer has contact tracing in place, that's certainly going to help determine whether or not that proof can be established. But some states didn't like that approach by the insurance companies, particularly in California and Illinois, where they've adopted a presumption that if you are working at the office or plant of the employer, then you contracted the virus in the course and scope of your employment and therefore are covered by workers' compensation. So that kind of has resolved the issue to date. Missouri, the insurance companies are still taking the position that there is no such presumption and that you have to have established proof that you contracted the virus at work. The other issue that comes up a lot is under federal law and the Occupational Safety and Health Administration Act, which generally OSHA has rules and standards which apply to specific instances, like when you have to wear a respirator if you're working in a coal mine or in other places where there's a lot of dust in the air. Are you working somewhere near a saw where you could lose a finger? It would have specific standards. There are no specific standards for this type of a situation where you have COVID-19. So therefore, you fall within the OSHA General Duty Clause, which is set out here on the slide, which is you have a place of employment and employment terms which are free from recognized hazards likely to cause death or serious physical harm. So, and if so, have you taken, or has the employer failed to take reasonable steps to prevent or abate the hazard? I think the keys for employers in this area was the hazard has to be something that was recognized. And I don't mean that we all know that the virus itself is recognized, but did you know you have a hazard in the workplace? Did you know people have contracted the virus or that there's a cluster of the like forming? And have you taken feasible and useful methods to correct the hazard? Fortunately, OSHA has published guidance on methods to address the danger, and they spelled that out on their website, OSHA.com, DOL.gov will get you there as well. And generally they follow the guideline, the CDC guidance. So if you're following CDC guidance, generally you'll be okay under the general duty clause, and Connor will get into that in a little more detail in his presentation. Now, to give you an idea of the kind of theories which have cropped up, and in particular how claims that have been made and how they've been addressed to date, we'll kind of go over a few of the more recent cases. There was one here in the state of Missouri where employees at a meatpacking plant tried to get injunctive relief and a judgment that the employer created a public nuisance, meaning essentially that this is a hotbed of the virus being spread. People weren't being provided adequate work time to sanitize themselves. They were working in very close contact with each other. They were providing bonuses to make sure people were coming to work, and that means that people who were potentially sick were coming to work. And they weren't really providing people adequate notice whether somebody was had the virus as well. So the court in that case basically said OSHA here has primary jurisdiction to investigate its guidance, so we're not going to sit here and get involved in a case where OSHA really has primary jurisdiction. In this case, the plaintiffs, the first thing they did was file an OSHA complaint, and there were OSHA inspectors out at the plant already. So essentially the judge says, hey, look, OSHA's already out here. OSHA's already looking at this. I'm going to leave it up to OSHA. And in this case as well, I think that the judge said, we also determined that from the testimony that was provided that the employer was following CDC guidance as well as OSHA guidance. So therefore, I'm not going to get involved. I don't want to be monitored. I don't want to be in charge of the health of all these employees, frankly, and the judge making those decisions. I'm leaving that to the governmental officials, because it looks like the employer is trying to follow CDC guidance. McDonald's, interestingly enough, had a similar situation. And once again, plaintiff employees in California, in Oakland, complained that the employer wasn't following CDC guidance, that they were not following state and local governmental orders about how essential businesses could operate. They weren't following their own policies and procedures. So the court initially adopted or granted a temporary restraining order under a public nuisance claim. Again, you are creating a nuisance out there by basically providing an environment where you could breed the virus, expand the virus, the scope of the virus, and have additional people contract it. So once again, the court granted that injunctive relief, and eventually the matter was resolved. Same thing happened in Illinois, another McDonald's, where they were not telling people, according to the plaintiffs, that other people had contracted the virus. They were not requiring them to quarantine after they sent them home. They were providing them inadequate masks, and generally they were not following the state and local governmental orders or CDC guidance. Essentially, and if you look at the court's order, which specifically granted their injunctive relief, the employer was denying lawful sick leave requests. They were not telling people to stay home who showed symptoms of the virus. They were not deep cleaning the restaurant. They were not providing a social distancing policy. They weren't giving people gloves and masks. They weren't doing temperature checks, wellness checks. They were not providing paid breaks for hand washing. They were not having contact tracing with all those who might have been infected with COVID-19 or had close contact with someone while physically present at the restaurant. They weren't training the employees on social distancing consistent with the governor's executive order. So essentially, you think about that for a minute. Well, gee, that's all what we're probably all doing. Those are all what the CDC guidance is telling us we should do. And in this case, the employer wasn't doing that, so the court felt that this was a public nuisance as well as endangering the health of the employees and issued that injunctive relief. Now, they wouldn't allow the employer to be sued for negligence claims because they thought it was unclear whether or not, it was speculative whether or not anybody had been injured at that point or could prove they were injured or actually contracted the virus at work at that point in time. Similarly, Amazon had the same sort of thing with regard to public health standards, telling people whether or not, advising other people whether or not they should be, someone had contracted the virus or they were exposed to someone who had contracted the virus, failing to follow, again, the public standards set up under New York law. That one eventually got resolved, again, because there was evidence that they were following the CDC guidelines. In Texas, prisoners sued and said that we are either we are generally high-risk people, we're disabled high-risk inmates. The prison isn't taking steps to protect us, and the district court below generally granted them an initial injunction, and then on appeal, once again, the court modified the injunction and said, basically, the evidence was that the prison was following guidance from the CDC and medical professionals, and we're going to modify the injunction accordingly. You don't have to go beyond what the CDC provides. So once again, you hear, again, the judge in this case, I think, was very clear. The judges, they don't want to be involved on a day-to-day basis policing everybody's workplace. They're going to leave that up to the governmental officials to make those health determinations. In prior cases, you have the same sort of thing where, you know, a dentist was not following standards of care under the CDC, under OSHA, and as a result was spreading hepatitis and HIV and the risk of that. Other cases, the same sort of thing, which we've cited here, all tied into the CDC guidelines. So what does this all show? Generally, as we've said, follow the CDC guidance. That is the general standard of care. And then we'll talk about it in a few minutes. That also applies to the standard of care for negligence claims. Follow the OSHA guidance. Follow the state and local orders establishing the standard of care. And for goodness sakes, if you have policies, follow the policies and make sure they're being followed. If you can't follow the policies and don't have them, just fall back on the CDC. But if whatever you have, you need to be sure that you're following them consistently. Some states were worried about the employer liability issues. If they're one of your jurisdictions, we noted here, they have provided some liability shield legislation in those states. Generally, even in those cases, gross negligence, like not following your own policies or grossly disregarding CDC guidance, are going to be an exception. Recklessness, intentionally doing it, those are going to be exceptions. But at least in those states, you have some liability shield. No such luck here in Missouri, Illinois, or California, or Texas, or other states. In terms of theories of liability, we've talked about negligence. You're going to be liable for the actions of your employees if they are engaged in the course and scope of their employment in causing an injury. So if an employee has the virus, is out there working, you know, in the grocery store, at the checkout counter, and it's proven, of course, that they conveyed that virus to other people that they were in contact with and infected them, you could have a claim if you knew or reasonably should have known that someone had the virus. So again, the point that is why people are taking all the steps necessary. Let us know, temperature checks, wellness checks, stay home if you're sick, providing that kind of, establishing that kind of guidance protects you in the long run on the theory of liability to people out in public. Kind of set out here the basic standard. The question is, generally, what is your legal duty? Your legal duty would be, is there a foreseeable likelihood that acts or omissions will harm somebody else? Are you aware of the risk that a risk exists? We've had this before, and most of the cases are, did the employee, the individual, or the employer know or reasonably should have known that there was an unreasonable risk of harm? So, the classic ones were the sexually transmitted disease cases where somebody knew they were infected or reasonably should have known they were infected. They didn't disclose or warn their partner about it, and so therefore infected the person. Or the same thing if they have tuberculosis and they knew or should have known. In each of those cases, again, that's the general standard. So that's why the more types of standards and policies you have in place to make sure you're doing the temperature checks, you're doing the wellness checks, you are telling people what the symptoms are, and to stay home and quarantine, by the way, when they stay home, that's going to be important. Obviously, you still have to prove there is causation, and causation is going to be a problem anyway for the reasons we've talked about. Can you prove that someone actually contracted the virus from an employee as opposed to any of the number of other places where all of us out in the world may have contact with people occasionally from time to time. Again, contact tracing tends to eliminate part of that proof issue if 5, 6, 7, 8 people at work all contracted it at work. Same kind of standards we talked about for knew or reasonably should have known, provide for negligently supervising employees, failing to follow your policies, failing to make sure everybody's adhering to CDC guidelines. That's going to be the issue where you might have exposure for negligent supervision. So if you know anything, you probably already know it, but following the CDC guidance is important. And don't forget that that's changing all the time, so you got to occasionally really check on that periodically, or make sure you've got updates. So you're on the CDC website where they give you an automatic update on guidance if that's possible. Make sure you're getting that because they are changing. And frankly, as Connor and Art will talk about a little bit later, as a practical matter, a lot of times we're seeing the governmental agencies just kind of overnight, on a Friday night or whatever, update their guidance from time to time. So you got to we try to keep up with that and let you know about those types of changes, but certainly it's something to be on the lookout for. And that includes, for state and local guidelines as well. And we all know those vary from, local counties to various states. And from time to time, they're revising them in somewhat confusing ways. But it is important that you're following whatever the guidance is in your jurisdiction from the public health department. As we talked about a little bit, and we'll kind of skim through part of this, but one of the big things here is public nuisance cases have tended to be an area where plaintiffs' lawyers have focused on. Interestingly enough, it used to be the case, we've seen it in any number of areas. There have been the opioid cases where the sued opioid manufacturers claiming they created a public nuisance because they had a risk that there would be people that were addicted, that it would cause harm to a large portion of the public as opposed to specific individuals, and it substantially interfered with public health, safety, and peace, and injured people as a result. We've seen that that's also been tried in the case of gun manufacturers as well. And now it's expanded in some cases to situations involving COVID-19, particularly for employers who have experienced an outbreak in their facility and continue to operate that facility even after there's been an outbreak. There was a lot more of this in New York, for example, where people were complaining about the fact that certain essential businesses were continuing to operate even though they had substantial outbreaks, and that was creating additional problems in those states and creating a public nuisance. So these are the general standards here. I cited you some from Missouri. Is a nuisance being created in an area where they have a legal right to go, like a public park or the like, is an example. The general standard for public nuisance, in most instances, are going to be, is it something that would have a general effect to a significant portion of the public as opposed to specific identifiable persons. For example, the classic example is public or lead paint manufacturers. There have been public nuisance suits brought against lead paint manufacturers, which generally, in a number of cases, have been rejected because the courts would say, well, that really is more specific to someone who has a home which has lead paint in it, and that's not a nuisance to the public as a whole, but only to those people who have lead paint in their homes. But that still remains an area where employers have some concerns about being shut down under a public nuisance case. And that is certainly the case in California, where it's seen that, which is a little bit of a broader standard than in other states because they have a statute to that effect. And we've just cited a few of the principles there in California. The interference must be substantial and unreasonable, and that's always a significant issue. So who knows what that will be ultimately will end up being considered substantial or unreasonable in a particular situation in California. It's going to be similar in other states as well in terms of the nuisance claim, but it's got to affect the public as a whole. Again, generally, if you are in a situation where you are following CDC guidance, where you are telling people, talking about the standards and the like that Connor and Art are going to be talking about, and you're following those, you are generally going to be far less at risk of having a lawsuit or being subjected to a public nuisance claim. And there may be times, frankly, where just because of the risk, you may need to shut down for a couple of days and the like, or at least curtail operations in the area where the outbreak occurred, if at all possible. Obviously, you're having a plant, you can't shut down the entire plant. But, you know, if you have a call center and you have a problem on one floor, you may be able to shut down that floor, move that elsewhere, move the calls elsewhere, or the like, for example. Now, the other issue that comes up is about reporting obligations. So what happens if someone has you find out that someone called in that's an employee and says, hey, I've tested positive for COVID-19. All the states and many of the counties and cities have reporting obligations regarding infectious diseases, and that includes, situations with, even, botulism or food poisoning or the like. There are mandatory reporting obligations. Traditionally, that would apply to, and in all states really, it applies to healthcare providers. There are also, in certain states, rules regarding reporting that apply not only to healthcare providers, but to educational institutions as well, daycare facilities and the like. There are mandatory reporting obligations to the local health department or the state health department in those circumstances. I'm going to note for you that in some jurisdictions, that may also apply to employers in general. And in some situations, it will apply to employers where there's no, quote, healthcare provider in attendance. That is the general standard, which tends to be in a lot of the laws. So you may say, well, gee, what does that mean? Do I have to report something? Should I have reported something? And the answer would be no, not specifically. What you should do, of course, is consult that. But the first thing to do is going to be asking the employee, have you seen a doctor? Has the doctor diagnosed it? Has the doctor reported it? Can you confirm that the doctor has reported it? Because at that point, it's been reported to the public health department. As a practical rule, and we're not giving you legal advice here, it's a practical matter. The state doesn't need to know, or the public health department doesn't know from 5 different people that one person tested positive. They need to have the report, and they need to go ahead and then do their job in terms of doing the contact tracing and the like, which they are going to do in most instances. So I think the first thing, the second thing you should draw from my presentation, other than CDC guidelines, is clearly under these circumstances, can you please confirm when there's a positive test that someone has actually reported it. And then under those circumstances, then you can decide, at that point, you can kind of leisurely determine whether or not you have some obligation over and above that. But generally, employers are not going to have that obligation to report. It's only in a few limited states and counties where you might, for example, Los Angeles County, there's going to be an issue, and in the city of Los Angeles, there's an argument that you have an obligation to report. In most states and locales, that's not the case. But the safest thing always to do is confirm that the employee has reported, and the doctor has reported this on. And why is that? Because the public officials, particularly in the first month or two, were very aggressive in terms of their inspection and investigation rights. So just remember that public health officials have very broad discretion as to what they can inspect in your facility, when they can inspect, what records they can review, who they can talk to, and when they can do it. And they have a lot of broad powers in these emergency situations. So whenever possible, tell them what kind of steps you are taking. Obviously cooperate. And a lot of times, the first approach should be, okay, we're glad to set up a time for you to come over and inspect and talk to people. Here's what we're doing so far, so that they know that, you are just not an irresponsible, employer doing nothing, and, everybody's walking around without a mask and within 2 feet of each other. So clearly you want to take a look at, tell people what you're doing, respond promptly. Don't resist allowing them access. They get very unhappy about that, and they can cause you a lot of problems. You certainly can do your own contact tracing. Just remember that regardless of what you do on contact tracing, and certainly that's what CDC guidance is suggesting, the primary responsibility is always going to be with the state. They may be doing, even if you do it up front and do contact tracing and advise people, the state's going to do the same thing. They're going to follow their responsibilities regardless of what you do. And when you contact people in your own process, you may advise them that they also may be contacted by the state. So hopefully that provided a general overview of the concerns you might have regarding exposure to liability and what your reporting obligations may be to the state and public health authorities. I think that will inform your guidance as we talk about more of the details here with Connor and Art. Thank you.
Thanks, Chuck, and thank you all for joining us this morning. Next, we're going to look at reopening in compliance with the Occupational Safety and Health Act, the OSHA Act, which is enforced by the Occupational Safety and Health Administration. Specifically, we're going to start with how OSHA is enforcing the Act when it comes to COVID-19, and then we're going to look at OSHA's guidance on reopening your business in compliance with the Act, how to respond when you receive an OSHA complaint, and then finally, what are your recording and your reporting obligations when it comes to OSHA? OSHA is tasked with, it's the branch of the federal government that's responsible for ensuring that employers are providing safe working conditions for their employees. They also enforce several safety standards for employers. Many of these are specific to certain industries, and as Chuck alluded to, and we're going to talk about shortly, the General Duty Clause provides a general duty to all employers to provide a safe working environment. In addition to federal OSHA, there are also currently 22 state plans that cover both private sector and state and local government workers, as well as 6 state plans that cover only state and local government workers. State plans are very similar to OSHA plans, and in fact, they're monitored by OSHA, and they have to be at least as effective as OSHA in protecting workers. Many times, these standards are nearly identical and will have some minor variations that offer additional protections to employees, but it's important to understand if you are in a state that has a local OSHA, a state OSHA program, and understanding what their requirements are and adhering to those. OSHA, since the beginning of the pandemic, has received over 9,000 complaints related to COVID-19. As you can see from this chart here, a large amount of those have been related to healthcare facilities as well as retail facilities. State plans have received over 28,000 COVID-19 complaints. State plans, frankly, that's a lot of complaints over a fairly short period of time, and because of that, there's going to be, OSHA has to prioritize how they're going to enforce the Act. OSHA's stated priority right now is to handle and prioritize complaints related to COVID-19 cases. Now, most COVID-19 complaints are related to either an allegedly sick employee who's come into the working environment and possibly scared a coworker, or the alleged lack of appropriate PPE being provided to employees, or employers not taking proper safeguards to protect other employees. Now, I say allegedly sick employee. I think it was the first, I believe it was the first OSHA complaint that I worked on was an employee that had come into work, and an employer that had taken many, if not all, of the right safeguards, and the employee was simply cleaning his work area as he should have been, disinfecting it, using a spray, and when he was using it, one of his coworkers opened his door, and that disinfectant spray went into his face and caused him to start sneezing uncontrollably for a brief period of time. And of course, this was at a time, I think this was back in the early days of the pandemic, this caused a large stir in the working environment. And one of the fellow employees, got so worked up about it that they complained about this employee being at work, believing that this employee had COVID, when, as it turned out, he did not. It was just simply an accident, and he was suffering from a sneezing bout from the disinfectant getting into his respiratory system for a moment. Receiving a complaint doesn't necessarily result in an on-site inspection or a citation. The majority of the OSHA inspections and citations have been issued to medical facilities and senior living facilities. OSHA is really focused with they have to prioritize COVID-19, and even within that, they have to prioritize, and they are prioritizing medical facilities and those frontline workers and attempting to protect them as much as they can. And so that's really the focus of the enforcement actions. Those complaints that have resulted in citations, and there have been some, and they've been for thousands of dollars and some tens of thousands of dollars, have been predominantly related to proper respirator use or PPE issuance and usage. Now, again, the vast majority of those citations have been, and inspections have been with medical-related facilities or senior living facilities. Inspections are conducted at the discretion of the local OSHA office. Now, fatalities as well as imminent danger exposures related to COVID-19 are right now being prioritized by the local offices. Other formal complaints alleging COVID-19 exposure where the employees are maybe involved in medium, lower exposure risk tasks, those may not result in an on-site inspection. When there's other non-formal procedures, and we're going to talk about those in a moment, can address the hazards. What commonly happens is that OSHA will get a complaint. An employee, like I mentioned before, will voice a complaint about the employer not taking proper safeguards, or a fellow employee that they believe is sick and is exposing other employees and making the environment unsafe. And they'll send a letter to the employer notifying them that a complaint has been filed. And at that point in time, they'll ask the employer for information and documentation about the incident and ask what happened. At that point in time, if your business appropriately responds, OSHA will very likely leave you alone and not pursue the matter further. Again, their priority is deaths and imminent danger exposures, as well as those that occur in medical facilities and senior living facilities. Inadequate responses, though, to those phone or fax investigations, if you simply ignore the phone call, you simply don't respond to the written complaint, the OSHA office is very likely then to follow up and conduct an on-site inspection. So you can go ahead and avoid that by ensuring that you're following their guidance and then appropriately responding when called upon. Now, as Chuck mentioned before, there is no specific OSHA standard covering COVID-19, and as far as we know at this point in time, OSHA has no plans on doing so. However, the general duty clause is applicable and is the clause by which OSHA is expecting employers to comply with when it comes to COVID-19. Again, this requires that employers provide a generally safe working environment that's free of hazards that could cause death or serious physical harm. There are some other potentially applicable OSHA standards. I've got them listed for you here. We'll talk about recording and reporting injuries and illnesses in a moment. Other ones that apply or could apply depending on your industry involve PPE, eye and face protection, respiratory protection, sanitation, and then signage, as well as medical record. One thing to keep in mind is that many of these do not apply to general businesses. They will apply simply to specific job duties or specific industries. The general duty clause is the one that is the main focus for those employers who have less risk than, say, your medical facilities or your senior living facilities. Okay, so how do you ensure that you are appropriately responding and appropriately following and avoiding any possibility of receiving an OSHA inspection or a citation? Well, it's to follow OSHA's guidance. OSHA has standards and regulations that apply to different industries. Of course, there's no one-size-fits-all COVID standard, so they provide guidelines, and they're going to apply to different companies, different job duties, just depends on what industry you're in. Now, this guidance that is online and has changed and had a few different iterations is consistent generally with the CDC guidance. The two go hand in hand and have been collaborating to ensure that they're on the same footing when it comes to advising employers as to how they should return employees to the working environment. Now, it's important, as Chuck mentioned, these standards can change from time to time. So it's good to regularly check maybe every couple of weeks to see if anything new has come out, if they're saying anything new. I know you're all familiar with that. But again, it's good to stay vigilant and make sure that you are following the most up-to-date information. Also, make sure your reopening aligns not just with these guidelines, but also with your local stay-at-home or shelter-in-place orders, either statewide or countywide. The first thing that you want to consider when you're deciding how you're going to approach these guidelines and how they're going to affect or be implemented within your working environment is to assess what's your level of risk. What's the level of risk of the employees that are working in your working environment, and doing job assessments for each one of them. There's 3 risk levels according to the CDC and OSHA. There's high risk. Those are your employees that are working in the medical field that are highly exposed to the virus. There's medium risk, which are jobs that have close contact or within 6 feet of people, general public. Then there's low risk, jobs that do not require contact with people that are known to be or suspected of being infected. Or within 6 feet of the general public. Most employers are medium to low risk, and for our purposes, that's where we're going to focus today. Now, I realize, and as we go through this, I realize, as well as Chuck and Art, that many of you, if not all of you, have already started the process of reopening and doing much of what OSHA and the CDC recommends. That's great, but maybe there's certain aspects of your plan that you haven't fully implemented, or there's aspects of your plan that could be improved upon by adding a few things. And so we're going to go through the guidelines in some detail, and some of it might be old habits for you by now, but it's always good to have a refresher to know that this is what's expected and that you're protecting yourself, not just from OSHA inspections or complaints, but as well as Chuck was discussing before, liability. OSHA recommends you open in phases. Now, they first advise employers to open in phases. This is not required, but of course, it depends on the nature of your working environment. As long as if it's feasible, they recommend opening. Consider implementing staggering your employees' return to the workplace. Utilize telework where possible, and limit travel, limit unnecessary business travel. I know that many of you already worked through phase 1 or are in the process of working through phase 1. And I know that here at Thompson-Coburn, where we are in the middle of working into phase 1, it just depends on your working environment and your level of comfort and the community that you live in and other factors that you have to consider. The second phase, of course, is just a reduction of the restrictions. Still consider making telework available. Non-essential business travel can resume. Limit the number of people in the workplace can be eased, and continue to maintain moderate to strict social distancing practices. And then finally, phase 3 would be just business as normal. While reopening, and regardless of what phase you're in, OSHA guidance tells employers you should implement strategies for hazard assessment, basic hygiene, social distancing, identification and isolation of sick employees, implementing workplace controls and flexibilities, as well as employee training. A lot of what OSHA recommends, and we're going to get into the details of these, is very simple. And there's really not much of a good excuse to not do it. And by following their guidance, you're really protecting from liability and protecting your employees, most importantly. First is hazard assessment. We really just already talked about this. You need to determine how, where, and when, and what sources of exposure exist within your company. What job duties have more exposure? How can you protect those employees? And really doing a job-by-job assessment of what you can do and what the risk factors are. Next is hygiene, and this is an important one, and something that that OSHA looks at very, very closely. Are you providing What are you implementing practices for hand hygiene or respiratory etiquette or cleaning and disinfection? Are you providing soap and water and paper towels to your employees? Are you providing sanitizer, encouraging that use of the sanitizer? Have you identified and targeted high traffic areas for enhanced cleaning and disinfection? And are you, in fact, cleaning and disinfecting those areas? The next one is social distancing. Limit business occupancy. Mark your floors in high traffic areas. Post reminder signs to your employees, not only about social distancing, but also about their hygiene, making sure that they know what the policies are and that these signs are frequently available and visible to them. Post directional signs in corridors that are confined or small spaces, making sure that it's very clear that employees are keeping their distance and are well aware that that's what we're expecting of them. The next strategy they look to is how are you identifying and isolating sick employees? And this includes the practices that you're implementing for worker self-monitoring and isolating, as well as excluding employees from workspaces, any employees that are showing signs or symptoms. You should be asking your employees to evaluate themselves before they come to work, checking to see if they have symptoms. If they're not feeling well, asking them to stay home. But although this should go without saying, making sure that you have a policy in place and reminding employees and training them on these policies is vital. Return to work after illness or exposure. Do you have a plan in place, and have you informed your employees of the plan for what they should do if they do, in fact, contract COVID-19? Latest CDC guidance for discontinuing self-isolation and returning to work. Employees should have 10 days since the symptoms first appeared and 24 hours with no fever, and as well as other symptoms are improving. Other return to work issues, if someone who's had close contact with someone with COVID-19, they should stay home and quarantine for 14 days after their last exposure. That's the latest from the CDC. So encouraging employees to follow that guidance and follow self-isolation is another factor that OSHA looks to. What sorts of controls are you implementing? OSHA expects that you implement engineering and administrative controls, safe work practices, and if necessary, PPE for your employees. Some suggestions on how you do this, and I keep saying suggestions because OSHA doesn't, again, have a specific standard, but this is guidance that they've implemented and suggested to employees, depending on whether it's feasible, for employers to follow in order to avoid any liability or citations under the general duty clause. Now, one thing they encourage is implementing physical barriers or enhanced ventilation, staggering work shifts, limiting break room capacity. I know here at the firm we've taken the tables out of the lunchroom altogether. Discourage employees from sharing tools or equipment that might lead to close contact or unnecessary contact. Replace in-person meetings with video conferences, like we are on right now. Require face masks in public areas. Conduct temperature checks, and I know Art's going to talk about temperature checks in a little bit more detail. The next factor they look to is workplace flexibilities. What are your policies with respect to telework and your sick leave policies? Do these policies encourage or allow employees to maintain social distancing while continuing to do their jobs? The OSHA and the CDC encourage employers to evaluate your existing policies, consider the appropriate use of telework. It might not be appropriate, and many times it's not, but consider it in those circumstances in which you can. And then, of course, communicate with your employees about those flexibilities and really let them know what their options are. The last thing, and truly a vital thing and something I've mentioned already a few times, is training. It's one thing just to implement all these things, all these suggestions and all this guidance, but it's another thing to make sure your employees know about it, and not just once, but constantly remind them through signage, through policies, through communications and presentations, making sure that not only are you training them on the exposure risk, and providing them access to additional information if they want it. But you're also training them about site-specific and job-related measures and how the employees can protect themselves and protect each other, including how they can use appropriate PPE. Now, one issue that frequently comes up when we get questions about this is face coverings and PPE and respirators and how these all fit together and what are our responsibilities as employers. Keep in mind, OSHA's PPE standards do not require employers to provide cloth face coverings to employees. There's no standard that necessarily requires that you provide your employees with cloth face coverings. Cloth face coverings are not considered PPE by OSHA. That's because they're meant to protect others and not necessarily the wearer. In contrast, surgical masks and respirators that protect workers from exposure to infections and toxic substances, gases, as Chuck mentioned before, dust, and in this environment, COVID-19, especially at hospitals, and in situations where you're working in close confinement with other people, those respirators must be provided with training. Now, more often than not, most employers, and especially medium to low risk employers, are not required to provide respirators, and that would not necessarily be an issue under COVID-19. But for those that it does apply to, such as medical communities, that has been a major focus of OSHA's enforcement actions. OSHA generally recommends that employers encourage workers to wear those cloth face coverings at work. Now, doing so is really just another manner in which the employer can show that they're implementing controls to reduce the spread of COVID-19. And this was all in compliance with the general duty clause. Also keep in mind, face masks, they may be required under local law, so make sure that you know what the local law is there. Another issue that Chuck mentioned is contact tracing. And contact tracing is a good way to, again, it's not required, but a good way to implement your policies and to show that you are taking necessary actions to comply with the general duty clause and protect your employees from undue exposure. Now, a few things to keep in mind. Prompt notification and follow-up reduces the risk that other employees are going to be exposed to the virus. You need to be prepared. You need to have a policy in place, and that policy should inform employees that if you do contract the coronavirus, they're going to be asked to provide a list of those individuals that they had close contact with while in the working environment. One suggestion is that you have employees, especially those that can and where feasible, you have them keep a daily log of where they're having conversations or when they're having conversations and who they're having conversations with. That could have been considered an exposure under the CDC guidelines. And at this moment, exposure is considered close contact with someone for 15 minutes. I think that's within 6 feet of someone for over 15 minutes, a 15-minute period of time. And so having employees keep a regular log of that during the day is one way that you can quickly start your contact tracing if an employee does, in fact, contract the virus. Another thing to keep in mind is make sure you're maintaining confidentiality. Never divulge the name of the infected employee beyond those conducting the investigation. Art's going to talk about that in a little bit more detail at the end here. And finally, follow up with your quarantined employees. Stay in touch with them. If an employee who's been exposed is at home, follow up with them to see if they're showing any signs or symptoms, because that may start the process over again. You may have to then determine who else to contact and put into quarantine. Okay, now that we know what OSHA expects, let's talk about how you respond to a complaint. If you get one of those complaints, fairly simple how to approach them. OSHA really wants to know what protective measures you have in place that you are taking to avoid the spread of the infection. They want to know what reactive protocols you have in place in case there is an accidental or an actual or potential exposure. And then finally, they want to know how are you communicating those protocols to your employees. Is it via writing? Have you had a presentation? They want to know all that information. And if you provide that to them, if you lay that out for OSHA, exactly how you're complying with their guidance, and including your written policies and photographs of your signage, and showing that you are taking care to protect your employees from the spread of the virus, there's a good chance they may leave you alone. One issue that comes up, and another issue that's been one that's been a focus of much discussion and concern about employers is what's your recording obligation when it comes to COVID-19 and OSHA. It is by OSHA, it's considered a recordable illness, so employers are responsible for recording it in their OSHA log if it is a case of confirmed COVID-19 and the case is work-related. Now, the confirmed case of COVID-19 is a bit simpler. As Chuck mentioned before, it becomes much more difficult to determine whether the case is work-related. OSHA is going to look at a few different factors when they look at whether you violated your obligation to record. And as I mentioned earlier, this is a standard that OSHA does take seriously, and one that comes up in the COVID-19 enforcement process. They're going to look at a few things. Compliance officers for OSHA are going to consider the reasonableness of your investigation into work-relatedness. What did you as the employer do to determine whether this was related to or occurred at work? A few things to keep in mind here. You're not expected to undertake an extensive medical inquiry. It's sufficient for employers you can ask the employee how do you believe you contracted the virus. You want to always be conscious of the employee's privacy rights, but it's okay to discuss with the employee his work and out-of-work activities if they have some idea of where they have contracted the virus. And also look at the employee's working environment. Are there other employees in the area that have contracted the virus? Are they working in a position where they have a greater risk of exposure? The next they're going to look at, the OSHA compliance officer is going to look at the evidence available to the employer at the time. What did you know at the time that you determined that it was not a recordable injury or illness? If you learn additional information and it changes your analysis, then you're responsible for then going ahead and recording that illness under OSHA. The last thing that they're going to look at is the evidence that the COVID-19 illness was contracted at work. They're going to look at it independently. Have there been several cases that have developed amongst workers that work closely together? That would be one sign that it was a work-related illness. Was it contracted shortly after a close exposure to a particular customer or the general public or a coworker that has a confirmed case of COVID-19? Is this employee working in a position that they work out amongst the general public? Is it something that they have a lot of community contact, and are they working in a community in which there is a high transmission rate? Those are all things that they're going to look at when OSHA is determining whether you properly or improperly followed the obligation to record a recordable illness. Now, if you've made a reasonable and good faith effort and good faith inquiry, the employer, if you determine that there was, that's more likely than not the exposure played a role with this particular case. If you determine that it did not, more likely did not, you don't need to record the illness. So you have to just make a reasonable and good faith inquiry, and as always, and as all attorneys will tell you, make sure you document what measures you took to investigate. It's always something that government agencies will look to, and if you can provide a contemporaneous record that shows that we did our investigation, this is what we considered, it's going to satisfy that reasonable and good faith inquiry. Now, keep in mind, if you record a COVID-19 illness, it doesn't in and of itself mean that you've violated OSHA. In fact, if it is work-related, and you fail to record it, that would be a violation of an OSHA standard. So it's important that you do the investigation, make the decision, and if you need to record it, it's not necessarily going to result in a citation. There is additional reporting obligations if the exposure at work results in either hospitalization, inpatient hospitalization, or in a death. If there's an inpatient hospitalization within 24 hours of knowing both that the employee has been hospitalized and that the reason for the hospitalization was because of a work-related COVID-19 case, the employer must report it. Employers must also report if an employee fatality they have to report it within 8 hours of knowing both that the employee has died and that the cause of death was a work-related case of COVID-19. These are very important, and these are separate obligations than just simply the recording requirement. These are not something you just simply write on your log. These have to be reported to OSHA. And there's various methods by which OSHA allows you to report. Last issue with respect to OSHA, whistleblower protection. Whistleblower protection, retaliation protection is a big issue. It comes up a lot in discrimination cases, and oftentimes it's the easiest to prove. If you're taking actions against an employee because they made a complaint or a safety complaint, that's going to be taken very seriously by OSHA. Thus far, as of late last week, there had been over 3,000 claims of retaliation for reporting COVID-19 violations. Now, over 600 of those have been docketed for investigation. I'm sure at this point it's probably closer to 700. OSHA does investigate these. They're a bit backlogged, but they will take them very seriously, and they will conduct a thorough investigation to see if there was any retaliatory action taken against an employee. So when you're reminding your employees about about all the precautions that you're taking and all the ways that you're protecting them and that they should be protecting themselves, it's also important to remind them that they are protected from retaliation, and they're encouraged to make safety complaints if they feel necessary. And by putting that in writing and including that in your policy, you're providing additional assurances that you're in compliance with OSHA. Next, we're going to move on to opening in compliance with the Americans with Disabilities Act, the ADA. An employer may bar an employee with the disease from entering the workplace because it poses a direct threat. The EEOC allows employees to go ahead and stop an employee from entering the workplace if they think that if they have it or if they think that they have it. It also, the EEOC says that employers may ask all employees who will be entering the workplace that they can be tested by the employer. Employers also may choose to administer COVID-19 testing while they're still working there. If all the employees, if you want to continue to monitor your employees, it is okay, according to the EEOC, to continue to have those employees tested to ensure that there is not a direct threat present. One thing where the EEOC draws the line, though, is that employers may not require an antibody test before allowing employees to re-enter the workplace. They said that that's not sufficient, and so that's where they draw the line. So a normal COVID-19 test is fine, but antibody testing is not something that you should engage in. We're going to go through a few accommodation examples, and I'm going to move through these very quickly. A lot of the information is really, I over-included it so you could read through these and get an understanding of how to approach these issues. But simply, does the ADA require employers to have telework programs? Or excuse me, does the ADA require can an employer require an employee to wear a mask? Yes, you have the right to require employees to wear a mask. OSHA encourages it. But if an employee with a disability needs a reasonable accommodation, engage in the interactive process. Ask them why they need it. You can get additional information and make an advised decision about whether you want to make an accommodation for that employee. Also keep in mind religious accommodations under Title VII. Now, many questions have come up regarding other reasonable accommodation requests, including telework programs and what particularly you can require of your employees when it comes to those types of situations, especially when they start returning to work and employees want to stay home instead of returning to the work environment. You're encouraged to stay and still engage in the interactive process. You can discuss any requests for accommodation and obtain necessary information, but again, it's important it's really the same practice as before. There's a little bit more leniency due to the extenuating circumstances, but the process should really be the same. Meet and confer with the employee, talk about a reasonable accommodation, and if you can reach one, go ahead and implement it. If you need to, you can always have a short-term temporary accommodation while you're determining what a long-term fix might be, but I just encourage you all to stay flexible and be creative in these times. You're not required to have a telework program, of course. If you do have one, just make sure you're equally applying it to your employees. What do you do if you have an employee that says that they have a disability that puts them at a greater risk of a severe illness if they contract COVID-19? They don't want to come to the working environment and they want a reasonable accommodation. They want to work from home. The CDC has identified a number of medical conditions that exacerbate and could put individuals at a higher risk. Clearly, this is a reasonable accommodation request. So again, engage in the interactive process, and where an employee has a disability and they've shown you certification, proper documentation, try to work on reaching an accommodation with them. A few accommodations and things you should think about while you're determining whether working from home is an appropriate accommodation. There's several factors. What's the employer's ability to supervise this employee adequately? Are there any duties that require the use of certain equipment or tools that can't be used at home? Is there a lot of face-to-face contact, interaction, coordination with work with other employees? Is there a lot of in-person interaction with colleagues, clients, or customers? And whether the position requires the employee to have immediate access to certain documents or information or equipment. All factors that you should consider while you're determining whether, okay, is this teleworking program an accommodation that we can provide to this employee instead of having him returning to the work environment? One thing to keep in mind, if the only reason that you think the employee should come into work is because their job involves some contact and coordination with other employees, that's not going to be enough. You're going to have to drill down a little bit further. If they have some job duties that must be performed in the workplace, then maybe they come into the office for those job duties, and they can do other job duties away from the working environment. Again, this is a give and take and an interactive process, and so ensuring that you engage in this interactive process is a good start in ensuring that you're in compliance with the ADA. Finally, if you've got an employee, let's say you've got an employee that wanted to work from home before. They said they needed to because of they needed a reasonable accommodation. This was all before COVID-19. Now they've been working at home for several months. It seemed to work out fine, and they come back to you when you start telling employees they need to return to the working environment, and they tell you, well, I can do my job at home. You can clearly see that as evidenced by the last few months. I would like to renew my request for an accommodation to work from home. Is that something that should be considered and can be considered by the employer? And the answer from the EEOC is yes. This certainly could change the equation, and employers are encouraged to take that into account as they engage in the interactive process moving forward. Last example is an employee entitled to an accommodation under the ADA in order to avoid exposing a family member who is at higher risk? And the answer is no. Although the ADA prohibits discrimination based on association with an individual with a disability, that protection is limited to disparate treatment or harassment. It doesn't require you to allow them to stay at home and do their job duties there, especially if their job requires them to be in the office or in the plant. But again, if you are doing this, make sure you're consistent with how you're applying these things, because if you're inconsistent, then that could be considered disparate treatment towards someone because of their association with an individual with a disability, and that is a violation of the ADA. Next, we're going to talk about other reopening issues. Can an employee refuse to come to work? The simple answer, there is no simple answer. Employees, if they have a general fear of coming to work because they're worried about contracting COVID-19, they cannot just refuse to come to work. However, if they can show that there is a real and identifiable danger, and they reasonably believe that that danger exists, and that another reasonable person would agree that there's a danger, as well as there's insufficient time to alleviate that danger if there haven't been protective measures taken, then an employee under OSHA could refuse to come to work. However, if you're following the OSHA guidelines and if you're being vigilant about implementing what we were discussing before, it's going to be very difficult for them to argue that. But again, you've got to make sure that you're following those guidelines. It becomes much trickier when it comes to a unionized workforce or the employee is advocating on behalf of other employees. The bottom line is if an employee is acting out of self-interest only for themselves and saying that they don't feel safe when you're implementing all these guidelines, they're not protected. But if the employee is acting on behalf of others or is a member of a unionized workforce, go ahead and pump the brakes, refrain from taking action against them, and seek legal counsel and get additional input on that, because those situations become much more difficult. If there's any question at all, I would advise you to refrain from taking immediate action and seek additional help. And I'm going to turn it over to Art for a few more issues that are a little bit more nuanced when returning to work.
Okay, thank you, Connor. And I want to make sure everybody can hear me. I'm calling from California, so it's long distance. As I speak today, there are 870,000 cases in California, and there have been over 16,500 deaths in Los Angeles County alone, 285,000 cases, and 68,000 deaths. And a reminder to everyone that 80 to 90% of the population of the United States is still susceptible to getting COVID-19 and the virus. That means that 250 to 270 million people are exposed. And I want to go through some of the practical steps based on the risks that Chuck has identified of litigation and the regulations that Connor has commented on. Essentially, the EEOC has, for the most part, reframed its regulations in favor and in deference to OSHA so that you can take steps to ensure that you have a workplace that is safe and safe to work in. On September 17th of this year, Governor Newsom signed a new bill that allows the state to track COVID-19 cases in the workplace and expands Cal OSHA's authority to issue orders otherwise known as stop work orders for workplaces that pose a risk of an imminent hazard related to COVID-19. And you should all be aware, no matter what level of risk your company is classified in by OSHA, that if there is an incidence of widespread pandemic in your workplace, OSHA and the state agency have the ability to come in and issue a stop order and shut you down. The law takes effect on January 1st. Other states are following suit, and the employer should prepare to make changes that are consistent with this new law. The law requires that you provide written notice to all employers and employees and employers and employees of subcontractors who are at work where they may have been exposed to COVID-19, to provide written notice to employees and their representatives, including unions and sometimes attorneys, that there's been exposure, written notice to employees and their representatives regarding related benefits, some of which have been discussed: workers' comp benefits, COVID leave benefits, paid sick leave, and the company's anti-discrimination, anti-harassment, anti-retaliation and policies, as well as whistleblower protections that I'll discuss in a minute. When an employee is coming into work, you have the right to question the employee, and you should do that. There should be a disclaimer presented to the employee, each employee, as they come in, that they are either working remotely and not coming in that day and turning around and leaving, or that as they're coming into work, they agree that they have not had COVID-19, that they have not been tested, or that the test was negative, that they have not had contact with anyone who has had COVID-19, that they have not had a fever in the last 48 hours, a cough, or congestion, or other digestive tract issues. You want to know whether they are going to wear a mask at work, which is highly recommended. You want them to know that they are going to report any coworker who they see who is not following your prescriptives. You want them to agree that they will keep a distance of at least 6 feet from coworkers, and you want them to understand, coming in the door, that they can be sent home, disciplined, or terminated for violating any of the company's rules. Temperature checks. As Connor has discussed, temperature checks are allowed. The EEOC has released a guidance that allows employers to undertake steps that might otherwise create ADA issues or Rehabilitation Act issues, that permits employers to ask employees if they're experiencing known virus symptoms or shortness of breath or other symptoms which the CDC has noted. Employers have wide discretion on testing of employees as they return to work and taking their temperatures. Now, test kits are generally not available to employers in most situations. They are in healthcare facilities, but most employers do not have the ability to undertake testing, that is a mouth swab or a nasal swab. However, digital thermometers are available and can be used and easily purchased for not too much money. The normal temperature below which one does not have a fever is 100 degrees, 0.4. And if you're taking temperatures and an employee has a temperature above that level, you have the right to send the employee home. If you do have an employee whose temperature is above that, it's a good idea, if you're going to send the employee home, to take the test a second time to make sure the first result on a digital thermometer was correct. The checks should also apply to vendors, contractors, messengers, delivery persons, and you should conduct them each day at each entry. The employer should keep records of temperature checks by name, title, date, and the time of day when the test was taken, and should keep those records separate from other records. The records that you keep of the temperature checks are among the best evidence that you're going to have if Cal OSHA comes in, or OSHA, your local OSHA agency comes in, or if there is litigation and you need evidence because you're sued to show that you've taken appropriate precautions. Testers, that is the individuals who you assign to take temperatures checks, should be well trained to recognize all of the symptoms. They should know that fevers, chills, coughing, sneezing, and prior contacts with people who have had those symptoms are appropriate. Depending on how much discretion you want to exercise, how far you want to dig down, you can ask, did you carpool today? Did you come by bus or by train? If you carpool, did you carpool with a coworker or with a non-coworker? Did you drive your child to school with another student in the car with you? Do you know whether that student's family has been quarantined? You can also ask an employee to show you masks, their mask. You need to know that if an employee has a mask, you want to know what kind of mask it is, because masks are of different qualities. An N95 mask, generally available from Amazon or drugstores, the best mask an employee can have. You can ask the employee if they have a cloth mask, if they launder it regularly. You're not obligated to supply employees with masks. If you do, you need to probably provide them with a mask on a daily basis, which obviously involves some expense, but again, it's a good investment. It's protection. Testers can require individuals to fill out a written questionnaire covering these same issues. There should be, if you're having tests, there should be at least 2 testers at every site and at every entrance into the site where employees are going to come in. And there should be 2 digital thermometers that are being used simultaneously. The testers are in the same risk level as healthcare workers. They're going to be exposed almost for certain over time to someone who is test positive or has an elevated temperature. They are likely to be exposed. The people who are taking temperature checks should be themselves tested at a testing facility at least once, preferably twice a week, and you need to pay for them to take the time off to get the test to show that they have not contracted the disease so that they're not passing it on to others. They should have safety equipment. In addition to a face mask, you should consider providing a plastic face shield, a fan that blows out of the room toward or the area toward another, toward the person who is being tested or being checked, so that that person, if they're infected, their breath, their sneeze doesn't come in the direction of the tester. They should also have hand sanitizers and alcohol wipes. And if you're a larger facility and can afford it, you should have a defibrillator, and you should consider going to a recreational store, an outdoor hiking store, and getting a couple of bottles of oxygen. You should wipe the thermometers on a regular basis between every check, and make sure that if employees are writing out a form attesting that they don't have any of these symptoms, that you clean the pen on a regular basis. Many of you have been to a doctor's office, you know that's what the doctors do. Testers should be authorized, let me go back one, to deny entry. They should have the ability to say you can't come to work that day because your temperature is elevated or because you have other symptoms. The tester should have a relationship with a designated, more senior manager trained to enforce the denial, probably in a more private area than where the testing is taking place, so that the designated manager can tell the person who is being denied entry, you can't come to work today, you can't come to work until you've tested negative and prove it to us, or present a doctor's certification. This is no time to be sympathetic. Everybody wants to come back to work to earn a living. They have family responsibilities, but it's imperative that you protect the company from having someone in the workplace who has COVID-19 symptoms. It may be necessary to have a restraining order. You may want to have a relationship with a lawyer who you can call if you need to get a restraining order. Privacy issues are very important. It's important not to identify in front of others someone who is being sent home. If you have a long line of people who are socially distanced, who are being tested as they come into work, and you say to one person, go home, everybody else knows that that person has an illness, and under the California Constitution and under the California Consumer Privacy Act, you probably violated that person's privacy. So do not identify people in front of others who have tested positive and are told to go home. Face masks are important. As Connor discussed, the EEOC has stated that an employer may refuse to entry to persons who do not wear an appropriate mask when the circumstances require. It's obviously a problem when people are eating lunch. They have to take their mask off. They may need to take a mask off during a rest break. But for the most part, the most cautious position you can take is to require everyone to wear a mask. Restrooms present a special problem, as most facilities are designed to accommodate more than one person at a time and at close quarters. But an employer can take steps to limit the number of people who are in the restroom at one time, to have a hand sanitizer outside, so if a door has to be open, it's with a clean hand. Hand sanitizer inside so that it can be used when exiting, and even wipe down guidelines posted on each stall. Regular sanitizing of work areas, including restroom facilities, is advised. I'm going to skip this one in the interest of time. Cal-OSHA and OSHA and the comparable safety enforcement agencies of several other states have already dictated that a notice must be given in detail when a workplace has been exposed to COVID-19, as I mentioned. California and several other states have already implemented this. Many states mandate that both employees and subcontractors who are at the site be notified within 24 hours of the infectious period when they may have been exposed. And notice should be given to each person who was exposed of their obligation to disclose to you any other coworkers with whom they have had close contact. Finally, the employer should engage in as much contract tracing beyond that to the extent possible. There are some pay issues that you need to be aware of. If employees are standing in a long line for a long period of time and haven't clocked in, there is law, at least in California, that says you have to pay those employees for the time that they are standing in line waiting to be tested. There are also reporting time issues. When someone shows up, is test positive or their temperature is above 100.4 and they're sent home. You may have an obligation to pay them for minimum time. And that minimum time in California is at least 2 hours or half of their regularly scheduled day. With that, I will conclude and see if there are any questions that anyone has. Have any questions been posted? If not, we'll wrap it up. Thank you for attending. We appreciate your interest in this very topical, important program. Please join us next Thursday, the 22nd, where we will have an employee benefits update related to COVID-19. Thank you again. Thanks to Chuck. Thanks to Connor. And thanks to everyone for attending.